ESI, electronically stored information, and e-discovery. The negative effects of not being ESI and e-discovery savvy in today's legal environment. Not conducting e-discovery. Attorneys not conducting e-discovery are not conducting discovery. Attorneys who ignore or neglect electronic information ignore the bulk of the evidence. They risk sanctions, malpractice claims, and disciplinary action. Failing to preserve and produce e-data. In Coleman Holding Inc. versus Morgan Stanley Inc., a Florida state court determined that Morgan Stanley failed to preserve and produce e-data and imposed monetary sanctions and revoked the Pro Hoc Vici admission of counsel. A $1.4 billion judgment of malpractice was entered against Morgan Stanley. Knowing clients' e-data systems. Lawyers are required to become familiar with the client's electronic data, systems, storage, retrieval, archiving, and retention policies and practices. In Zubalake versus UBS Warburg LLC, the federal court emphasized the requirements that lawyers be proactive in the preservation, search, and production of electronic data. Addressing e-discovery issues early on in litigation. New federal e-discovery rules require early disclosures and discussions and permit orders at the case management conference. Time and money spent early on is a good investment in risk management and case preparation, even if the results are not immediate. Presentations in court. Judges want to make great decisions, but without the assistance of lawyers providing facts and information, it is almost impossible. Judges want to be educated. In that education process, the quality of declarations from the attorney's client and expert are critical. The quality of the presentation to the court often determines the final outcome. Developing litigation management policies. Inform clients of the cost and benefits of effectively collecting, processing ESI. Educate and train members of the IT and litigation support departments. Communicate clearly with clients regarding best practices for handling original ESI. Embrace and utilize technology effectively. Follow industry standards and protocols to avoid sanctions and/or malpractice. The future is bright. Thus far, lawyers and courts have focused on the dark side of e-discovery: delay, burden, new layers of experts and service providers, massive increase in volume of data and the time and expense to review it, etc. The bright side is better access to new and invaluable information, cost savings, and better presentations as lawyers progress towards paperless litigation. Information can be obtained and analyzed, organized, stored, recalled, modified, manipulated, and used when needed. ESI and e-discovery is the future.